Pinkston, if you have my time, I
Yes.
need to rush you.
No, we're ready.
Okay. All right, let's go. Now we're ready. Let's go back on the record. And let me just start here. We'll come around. Mr. Pinkston, do you have a desire or a position as to my question? Proceed under the 400s or proceed under the
Right.
600?
Your Honor, I think the 400 code section, the 600 is incorporated into that, and so that the procedure for both, you can plead to a 605 or 615 violation in a 403 proceeding, which I think is what we're here for today. So therefore, I think the procedure followed in the 400s would be the same the court should follow in the 600 because the statute doesn't say otherwise.
It doesn't say so either, though.
That's true.
It's muddy. You agree it's muddy?
I agree it's muddy. Also, 403 talks about it incorporating 605. I agree it's not the clearest thing in the bill.
Mr. Houston, what's your client's position?
Well, our position, Judge, is that we would like to have a preliminary hearing on the 605, and we'd ask that the court delay doing anything on the 400 until we actually have the preliminary hearing. We'd sort of do it all at once. I think we're all in agreement.
We're all in agreement. Mr. Davis is the same. All right. How long do you need to prepare for that preliminary hearing?
Judge, I think the only issue we've got is we just want to make sure that we can have the medical personnel and the officer from Sevierville understand to be here. We think that's germane to the issue of their report. So, 10 days.
And of course, it'd be up to you to secure those.
Of course, yeah.
Sure. Then, out of an abundance of caution, and because this is it's clearly a Class A misdemeanor, and I believe constitutional rights apply to all criminal matters, although the statute seems to try at least to trump some of that under the 400. I mean, there may even be an argument made, and not that I wish this case would be protracted and prolonged that long, but somebody needs to clarify these statutes, either the Supreme Court or the legislature, because there are arguments that could be made even as to the 400 part of the constitutional issues, even though I've made my ruling known as to how my opinion known as to how I feel about that. Mr. Pinkston, when can the state be ready for a preliminary hearing? 10 weeks, 2 weeks?
Yeah, we're ready today, but 2 weeks, additional time's fine. We'll be ready. As long as we get
that week of the 10th.
maybe the first week of February, Your Honor, that'd be roughly 2 weeks.
Mr. Shorter, would you please go get my red book? I wasn't planning. I didn't plan well enough to bring that in.
Your Honor,
so if you'll be looking at your first available dates 2 weeks out.
well, Your Honor, I think maybe the criminal courts are closed the week of February 15th. That would be
For their conference.
It's usually in March, not February.
That's odd. I have a whole week clear, which is very, very unusual.
The sessions, and I'm not sure if you go to those as red bank judge, but the sessions is the 23rd and 24th of February, I believe.
Correct.
And ours is 22nd, 23rd, 24th.
Oh, do you really? Okay.
And so that may be, is criminal court another time?
No, Judge, apparently we just don't have anything in court that week. That would be a preferable week for me, though.
Thank you. We're all electronic here, and we'll do everything in the system except for the one red book that I still keep liberties with. So
I would ask if the court could do it the week of the 15th.
court is available Monday, February the 15th. I could court can be available on Thursday, February the 18th. Do either of those dates work for all four attorneys?
Judge, we can do either one.
The 15th or the 18th of February?
Judge, I think the 15th is okay. Everybody.
Monday the 15th?
Yes, sir.
Let's start at 9 o'clock.
That's fine, Your Honor.
That'll be for preliminary hearing on the allegation of failure to report sexual abuse under the 600s that we've been talking about. And we will go from there. Is there anything else the court needs to do in this matter today? Now, again, thank you, counsel, for your arguments. Let me say one thing, and I'm reluctant to say anything except for the statement that Mr. Davis made that public issue statements and things in this case have not been proved. These lawyers are doing their job. They're representing their clients. Mr. Kingston, Mr. Bright are representing the state. And everyone did a good job of trying to help me see clearly the issues before the court today. So for that, I thank you, and I thank you for what you do every day. All right?
Thank you. May we be excused?
Yes.